Good afternoon, Mr. Millett. If you are ready to resume, perhaps you'd ask the usher to ask Mr. Martin to come back in, please.
Yes, thank you, Mr. Chairman. Yes, may we please have Mr. Martin back in the hearing room?
Good afternoon, Mr. Martin. Before we resume your examination, may I just say this? All of us on the panel are aware that you've been giving evidence already for quite a long time, and I think we all understand that it's not necessarily an easy or comfortable thing to be doing. We shall have a break during the afternoon, but if you ever get to the point at which you would like an additional break, will you please just indicate, and that can be done without any difficulty.
Yes, sir, thank you.
Right. Are you ready to carry on now?
Yes.
Thank you very much. Yes, Mr. Millett.
Yes, Mr. Chairman, thank you. Mr. Martin, I'd like to continue asking you some questions about the meeting on the 2nd of July 2014 and FAQs. Can we please go back to the minutes? CLG 3019336, page 4, paragraph 3. And you can see there, we read it before. Just wait for it to come onto your screen. Yes, thank you. You can see the in the third paragraph down, it was suggested that clarification could be achieved by means of an FAQ. Approved documents can be downloaded from, and there's the planning portal. The page for each approved document also has an FAQ section related to that approved document. Sarah Colwell agreed to raise this with Brian Martin. Now, do you know, or did you ever find out who it was who made the suggestion that clarification could be achieved by way of an FAQ?
No.
In your witness statement, I think all you say about this is in paragraph 119 on page 42, and you say, I don't recall being contacted by Dr. Colwell in relation to posting an FAQ on the planning portal. Is that correct?
Yeah, as I say, I think I did speak to her at some point after the meeting, but she never directly proposed an FAQ to me. I think I asked her if there was something I needed to do, and she said no. I think she said not at this stage, but it's a very vague recollection, so right. I wouldn't want to hand on heart say that's what happened.
Her recollection was that she never contacted you about an FAQ after the meeting. That's her evidence, day 233, page 204, lines 3 to 6. I've summarised it, but it sounds similar to yours.
Yes.
Right. So just to be clear, I think you accept that no FAQ on the subject of the meaning of filler within 12.7 or the use of ACM with PE or otherwise combustible cause was published at any time by government after the 2nd of July 2014, was it?
That's correct.
Why was that?
I think in terms of this particular point in this meeting, I took that I'd wait for them to contact me with what they were proposing, but in the meantime I started opening up discussions with NHBC.
Who's the they in that answer?
The people that attended the meeting.
Why would it be up to them to contact you with what they were proposing, given that having read the minute you knew what the problem was and you were the one was with, as it were, a finger on the planning portal button and could put the FAQ section in?
It would probably be better, I thought it'd be better for a group of fire safety experts and cladding experts to draft something and for us then to look at it.
Yes, but why didn't you ask them to do that?
I understood that's what they were going to do.
But when they didn't, as it must have become apparent that they hadn't, at some stage fairly soon after this, why didn't you ask them?
I think this was a busy time for us, and I think I probably forgot about it, is the honest answer. I think I'd put it to one side and waited for them to contact me and then focused on the other work that I was doing.
Right. Well, let's see how we go with the rest of this. If you go, please, to BRE 30 47364. this is an email run which starts on page 2 with the bottom email in the chain sent by Brenda Apted to Sarah Colwell on the 24th of April 2014. And it's the same email that you got from Brenda Apted as well, isn't it?
Yes.
Now, you didn't see this one at the time sent to her, but I think we can take it that Brenda Apted had followed your suggestion that Dr. Colwell be invited. And if we move up to page 1, we can see an email from Sarah Colwell to her BRE colleagues. Page 1. Stephen Howard, Tony Baker and Debbie Smith following that email, and sent at 17:38 on the 24th of April 2014. And she says this is something we need to be aware of and should consider being involved with because of the increasing number of issues similar to those identified below, which we are being asked by industry. It also follows on from the discussion Tony and I had with Brian earlier in the year, which suggested that DCLG would be keen to see this type of document produced and then referenced in the FAQ area on the DCLG website. Now, first, were you aware that in April 2014 the BRE was still receiving questions from industry on the matters set out in Brenda Apted's email?
No, I wouldn't have known what was happening at BRE.
So you're sure no one raised these matters with you
No.
after November 2013, apart from the 30th of January email? Meeting, which you can't recall.
No.
Now, the discussion Tony and I had with Brian earlier in the year, I think is the meeting that you had with Sarah Colwell and Tony Baker on the 30th of January 2014, the invitation for which we saw during your evidence this morning. Yes?
Yes.
Does that help you remember anything about this meeting? That meeting?
I don't remember it, but these look like... It seems plausible. That's the sort of thing I would have said.
Right. Did you say at the meeting that the DCLG would be keen to see this type of document produced and then referenced in the FAQ area on the DCLG website?
I don't remember saying it, but it seems likely that's what I would have said.
Right. Dr. Colwell told us that she hadn't used the FAQ route before and that it was something that you had raised and would take forward. Day 233, page 203, 22 to 25. Was it, in fact, your own suggestion at origin that the FAQ section of the department's website should be used to make a reference to industry guidance on the kinds of matters listed in Brenda Apted's email?
I hadn't thought about that before. Conceivably, I might have mentioned FAQs as one of the options when I met with Mr. Baker and Dr. Colwell, and perhaps she then decided to propose that at the CWCT meeting.
Right. Now let's go to the top email in the chain, which I think fits with what you've just told us. This is sent by Sarah Colwell the same day, 10:36. 22:36 in the evening. This document has been around several years and was focused on curtain wall issues. The problem is now the issues we're seeing in the industry that are not clearly defined in ADB. Hence our meeting with DCLG earlier in the year and their suggested FAQ route. This CWCT revision would fit with that approach. We used to have good links to CWCT, but via BTG, but I'm not sure who's taking it on now. I'll follow up with Julie. Now you can see the reference to their suggested FAQ route. It seems from that that's likely to be a reference to your meeting on the 30th of January with Sarah Colwell and Tony Baker.
It seems likely.
Yes. So is it right that, going back to July 2014, you wouldn't have needed Sarah Colwell or anybody else to contact you in order to publish an FAQ on approved document B? You could have done that without any difficulty yourself, having read the minute.
I suppose so. I think at the time I thought they were working something up and waited for them.
I mean, as a matter of mechanics and possibilities at the time, we've heard evidence from Anthony Bird, Bob Leadsom and Richard Harrell, who all told us in their different ways that clarification of 12.7 to bring it in line with the intention of the Secretary of State back in 2006 could have been done by an FAQ at this point without difficulty. Do you accept that?
It certainly wasn't impossible. I mean, it would have taken some work, but yeah.
Yeah, yes, it would have taken some work, but I think you accept it. I mean, can we take it that there was nothing in the idea of publishing an FAQ on this subject that you consider to be unreasonable or inappropriate or disproportionately difficult?
No.
No. But I think what you tell us is you didn't do so because, in all candour, you forgot about it. Is what you told us before.
I think I owe the inquiry that candour, and I think that's the honest answer. I think I'd seen the minute that they were going to take the next step, and so I probably put it away from my mind and focused on what I was working at the time. It was a. It doesn't sound like a very. It's not an excuse. It's a fact. We were very busy on other things at the time.
Right. Let me just ask you one or two other things. Are you aware that after this meeting, a few days later, a few weeks later, in early September 2014, Sarah Colwell met Alan Keeler of CWCT to discuss the FAQ? Did you know that?
I didn't know it at the time. I'm aware of it now.
Did you know that in October 2014, 7th of October, at a CWCT members' conference attended by, among others, Sarah Colwell, members were told that CWCT and the BRE were in the process of obtaining clarification on 12.7 through the FAQ section of the building regulations website?
I wasn't aware of any of that.
Didn't know about that. That's right, isn't it? The clarification was not sought from you or anyone else in the department by CWCT, was it?
I think the next time I heard from them was in 2016.
March the 17th March 2016 meeting. We'll come to that later, but that was the next you heard, was it? Right. What about the BRE? Did any clarification or request for clarification come to you from the BRE after the 2nd of July 2014 meeting?
No.
Are you aware that Sarah Colwell told the CWCT in March 2015 that an FAQ had been drafted and was about to be circulated to the CWCT for their comments?
No.
Are you quite sure that wasn't mentioned to you?
I certainly don't remember it.
Do you remember having any kind of conversation or discussion about an FAQ with Dr. Debbie Smith?
No.
Was it ever suggested to you that an FAQ should not be posted on the website?
No.
You sure about that?
As sure as I can be.
Let's go back to your statement. You refer in your statement, please, at page 6, paragraph 18, that it's possible for, if you look at the bottom of the paragraph, you say one of the roles of the technical policy officials within the department can involve working with trade bodies, insurers, building control bodies, etc., to find interim solutions to issues with the regulations until such time as a formal review of the part of the regulations or approved document is completed. And that would I be right in thinking that would include FAQs? As an interim
yes,
solution?
I mean there's a limit. I think, as some of the other witnesses have said, is there's a limit to what you can do with an FAQ. Because it would be a formal document, it's essentially from the department or the Secretary of State, depending on how you look at it. What you can't do is change the law or change the approved document by the back door, so to speak. So you can only direct people to better information and explain things. So there's a limit to what you can do, but that's certainly one of the things that we've used in the past to try and resolve problems.
But you wouldn't, if you just clarified the fact that the word filler material applied, whatever else it might apply to, applied certainly to the core of a composite panel, that wouldn't be a change in the law or a change in the approved document. It would be a
I don't know if we'd been able to say it quite as directly as that, but we probably could have said it more directly than was what was in the approved document.
Well, you could just say that the word filler is intended to connote or include the core of a composite panel, and always was, according to your evidence. So no difficulty with an F.
As I say, I don't think I'd have been able to say it. I think we would have said something like "such as," because the point of that paragraph was to get people to look beyond just a single type of product.
Right.
So it would have probably been a bit more nuanced than you're suggesting.
Right, but putting it more bluntly, if you had discovered, as you did, it seems from reading the minute, that industry did not understand that an ACM with a PE core panel was effectively banned by 12.7, then that message, however it was phrased, could easily, I would suggest, be the subject of an FAQ posted with some speed on the department's website.
It's something we could have done, yes.
And similarly, you could have gone to the LABC, the BCA, NHBC, building control bodies, design associations, architects, construction professionals, and tell them.
We couldn't tell them what they can or can't approve. That would be a decision for them, but we could alert them to the issue and the concerns that have been raised.
Was there any element of your thinking about this at the time that you were proud and pleased with the work you'd done in drafting 12.7 in 2006, and in doing nothing, you were acting to protect the content of that provision, something I think which you described on occasions as your third child? Would that be fair?
No, I don't think that was what was going through my mind at the time.
Is any part of the reason that you did nothing to clarify the meaning of 12.7 the fact that the new wording for that paragraph in the 2006 version of ADB was not made the subject of public consultation or consultation with BRAC or ministerial scrutiny or any of the other matters that you say in paragraph 18 would be needed in the case of substantive change?
No, that wasn't what was going on. I think at the time my main concern is that we were heavily focused on other work at the time, and I think I was distracted from the issue. Right,
so just be clear for us, can you confirm that it was no part of your thinking that you had snuck it in under the radar back at the end of 2006 and were now worried that somebody might ask awkward questions about how the phrase filler materials got in there?
No, that wasn't my thinking at all.
Or that you, is it the case that you didn't, during the period from 2014 onwards, consider that there was any risk of a major fire in England and Wales due to the use of ACM panels with a polyethylene core?
Well, I could clearly see there was a problem. I underestimated the risk that ACM presented. I think if I'd fully understood it, I may have put more time into this issue. I completely underestimated the hazard.
Did you discuss industry's lack of clarity on the meaning of 12.7 of approved document B with any senior official at any time?
Not in relation to ACM, I don't think so, no.
In relation to anything else?
The other issue that had been raised at that meeting, which was the question of what insulation materials people were using, was something that came up, and as I'm sure we'll discuss at some point, I raised with the NHBC, and I discussed that with Mr. Leadsom and Mr. Harrell.
Yes, but not the need for clarity about 12.7?
No.
Why is that?
It just didn't register with me at the time. I don't think I recognised how serious it was. I guess it was a problem which was really peculiar to ACM, and I just didn't think it was that significant an issue at the time.
Right. Now, do you accept a decision? Well, did you discuss not doing anything with any senior official, Richard Harrell, Bob Leadsom, anybody more senior?
No.
So you never took this to them and said, a problem's emerged about the clarity of 12.7, we should do something about it?
No. At the time I took it as one of a number of routine debates about the application of the approved document.
Do you accept that in the absence of your raising this problem with them, your line managers and their seniors would have no way of knowing about it.
I mean, that wasn't unusual. I recognise that now, but that wasn't an unusual situation. I think all the officers in the team would be dealing with this kind of query all the time.
Let's turn then to the topic you just referred to, which is the use of combustible insulation materials over 18 metres, because you say rightly that it's also the topic of this meeting. And if we go to page 3, please, of the minutes of the meeting, you can see there's a heading, Combustibility of Insulation. And in the middle of your screen, you see that. And it says, limited combustibility insulation should be used above 18 metres when following the prescriptive requirements of ADB clause 12.7. But other materials, principally foil-faced phenolic foam, are often used in rain screen walls. There is a degree of ignorance, with some people confusing class 0 with limited combustibility. In other cases, building control officers are permitting the use of class 0 materials, making it difficult for cladding consultants to enforce the requirement for limited combustibility insulation. Higher standards of thermal insulation are requiring greater thicknesses of insulation, and in some cases this can only be achieved within the designated wall zone by use of combustible insulation. Architects are unaware of the problem and need to allow a wider wall zone to accommodate the greater thickness required with limited combustibility material. Now, do you remember whether you were present for that part of the discussion?
Yes, I was.
You were. Now, in your statement, I think you say, let's look at it, page 42, paragraph 120. You say this, during the meeting I do recall that it was suggested that some projects were using insulation products that did not meet the standard set in the ADB, and that this might be because of a misunderstanding of the different classifications. Now, what are the standards set in the ADB that you're referring to there?
The material of limited combustibility for insulation.
So 12.7?
Yes.
Right. and table A7, I suppose, as well. You were certainly aware, I think, that this was a current issue because you'd already corresponded with Neil Smith of NHBC a little earlier the same day on that very topic, hadn't you? You remember? The friendly warning email.
I'd never been quite sure in which order these things happened.
Well, we'll look at that in a moment. The friendly warning email came in the morning, and the meeting was in the afternoon. Take that from me, but we'll come to that. But let's look at something slightly different here. Can we go back to the minute, please, of the meeting, where you can see in the middle of the paragraph I've just shown you, 3 lines down, under the heading, it says, there is a degree of ignorance with some people confusing class 0 with limited combustibility. Was that something that you knew already in July 2014 before this meeting?
No, I don't think so. They're two things with different definitions.
Well, they are, indeed, as we know, but we've seen how the word combustibility or limited combustibility can be used perhaps imprecisely. Were you aware before the 2nd of July 2014 meeting that there was a degree of ignorance with some people confusing class 0 with limited combustibility? Did you know that?
No, I don't think I did.
So this would have come as something of a surprise, yes?
Yes.
Yes. And then looking at the next sentence in the minute, it says, in other cases, building control officers are permitting the use of class 0 materials, making it difficult for cladding consultants to enforce the requirement for limited combustibility. Do you recall that discussion?
I recall the general discussion. I remember, I can't remember who it was. It might well have been one of the engineers from Wintec thinking about it, but I couldn't say for certain. But it was somebody said that they'd found building control bodies that thought. My recollection is that they'd found building control bodies that thought polymer foam insulations were materials of limited combustibility. I don't remember the exact words are in this minute, right. But that's my recollection.
Did that come as a surprise to you?
Yes, it was a concern, and it seemed implausible to me, I thought it was well known that the foam insulations are not materials of limited combustibility.
Well, there are two confusions then, aren't there? I think here. First, the ignorance about whether or not foam insulations are materials of limited combustibility, and secondly, confusing class naught with limited combustibility. Both are apparent, I think, on the face of this paragraph, aren't they?
Yes.
Yes, and so there's a double surprise there. Is that right?
I suppose so, yes.
Did that not reveal to you profound ignorance within the building control community, if there were members of it who made both of those, or even either of those, confusions?
Well, there were no members of the building control community at the meeting, I don't think. So this was an accusation levelled against them. So whether it was true or not, I don't know.
Well, you say it's an accusation. It was a reflection of the members at this meeting's experience of some people and building control officers, maybe one and the same, maybe different. But the point is, isn't it, that there are two kinds of confusion out there: confusion between class naught and limited combustibility, and confusion about whether or not foam insulation is itself of limited combustibility. Yes?
I guess that's fair, yeah.
Yes. Now, what did you do after seeing those minutes or hearing that discussion about these two problems?
Well, I thought I'm confused by the timeline. I thought it was after this meeting that I contacted NHBC to ask them what they were doing on this matter. Right.
Well, let me show you the email. I'm about to show it to you, actually, so I don't want to get ahead of myself. I can tell you that the email is timed at 11:42 that morning, and it may be that you read the email after the meeting, but it was sent certainly beforehand. But maybe nothing turns on that. But let's just go back to this point. Did you carry out any inquiries of industry more broadly than the people at this meeting, or building control officers, to find out whether it was in fact the case that people were confusing class naught with limited combustibility and thinking that foam insulation was itself of limited combustibility? Did you do that?
Not directly, no.
Indirectly?
I think that's what's become known as the friendly warning email.
Anything else?
At that time, no.
Why nothing else?
I think I treated it as an allegation, was just looking around to see if I could find any, what feedback I could get on it quickly and easily, which is why I sent the email to NHBC.
Right. Well, we'll come to that, because I think it cries out to be examined. But before I do, and I don't want to prolong the moment much longer than I need to, can I just ask you one other thing? Can we go, please, to the witness statement of David Cookson of Kingspan Panels? That's at KIN 3026300, page 19, paragraph 2.106. And he says, one thing that does stand out in my mind from the CWC meeting is that when Brian Martin left the meeting, he said something along the lines of, there's going to be a major fire. My recollection of this comment is that it related to the quality of installation and the issue with cavity barriers, which is referred to under the heading rain screen cavity barriers at page 3 of the CWC minutes, rather than simply the use of ACM. However, I cannot fully recall. And he goes on a bit more about cavity barriers. Now, is Mr. Cookson right in his recollection? First, that you said, before you left the meeting, there is going to be a major fire?
I doubt I would have said it in those terms, but I don't remember.
Is there anything you can remember about issuing a warning along those lines?
I might have said something like that to try and encourage the people in the room to take action where they could.
Right. Was there anything raised at the 2nd of July 2014 meeting that caused you to comment or to think that a major fire might occur?
I know that we'd seen, in particular with cavity barriers, we'd seen a lot of incidents, probably mostly in timber frame buildings, where there'd been fire spread in cavities, and invariably the culprit, if you like, was poorly installed cavity barriers. It seemed to be. It's a particularly problematic building component because it's difficult to inspect because it's within the construction, and serves no function unless there's a fire. So if it's defective, if it's not picked up by quality control on site, it's very difficult for an inspector or anyone else to spot that there's a problem. And so certainly with, I think most of the fires were timber frame ones, but not exclusively, where there'd been fire spread in cavities and problems with the installation of cavity barriers had been an issue. So I think that was probably why I was pressing on that point, because we'd seen a lot of problems with cavity barriers and trying to get people with influence in the industry to help us improve standards.
Now, you told us that you hadn't escalated any of these matters with your seniors, apart from the question of the use of insulation, combustible insulation above 18 metres, which we'll come to. I just want to ask you about the minutes of this meeting. When you received them into the office, where did you keep them?
I can't remember.
And did you print them off and file them, or did you leave them in a PDF on your hard drive, or how did you store these minutes?
I think at that time we stored nearly everything electronically. The department didn't have a very robust record-keeping system.
Right. Did you think to send the minutes at least to Richard Harrell or Bob Ledson?
No, I mean, I attended meetings like this all the time. If I sent the minutes of every meeting I went to, they'd be inundated by, they wouldn't be able to do their own jobs.
Right. Did you send them a message saying you might be interested in this? And
no.
Identify the place on the hard drive or on the shared drive where you could find the minute? No.
No, as I say, I mean, I saw this as something. Everybody in the team had this kind of meeting with industry stakeholders fairly regularly, and so it wouldn't have been that unusual at the time.
Now let's look at the friendly warning email. Can we start with your statement, please? Page 42, paragraph 127. And you explain there, you say this, 127. I'm sorry, my misreference, page 44. And you say, after I returned to the department following the meeting, I followed it up by emailing Neil Smith at the National House Building Council, NHBC, which is the country's largest approved inspector and one of the leading home warranty and insurance providers, to alert him to the discussions I had had at the CWCT meeting. Now, let's then look at that email, please. It's at NHB 50712. If we go, please, you need to scroll to the bottom of the chain, down to page 4. Well, page 3, I'm sorry, top of page 3. There it is. And you can see that it's an email from you to Neil Smith on the 2nd of July 2014. But note the time, 11:42. Do you see that?
Yes.
Fire safety facades. Hi Neil, I've been talking to a few folk about fire safety and facades recently. Allegedly, several buildings have been erected where PIR insulation has been used in cladding panels well over 18 metres in height. Apparently, people are under the impression that PIR is a material of limited combustibility, which it isn't. Again, allegedly, many of these buildings are blocks of flats. I've no idea how true these allegations are, but they come from relatively reliable sources. The purpose of my email is a friendly warning. You might want to double-check with your inspectors and plan checkers that they are on top of this. Happy to discuss. Regards, Brian. Now, are you certain that, as you say in your statement, it was after and as a result of the discussions that you'd been involved in at the CWCT meeting that you emailed Neil Smith?
I thought it was, but I can see why you're asking me that question.
Yes, because if you look at the timing, it's sent in the morning at 11:42, but the CWCT meeting took place in the afternoon, yes?
I can't remember, but I'm assuming that's what it says in the minutes.
Yes. And I think your email clock was a 24-hour clock, wasn't it, rather than a 12-hour clock, so it wouldn't have been late at night.
No, that seems unlikely.
No, no. So we can rule that out. Now, we don't need to go back to it, but do you remember that the previous day, the 1st of July, you'd sent the email, you'd emailed CWCT to say that you'd been called to a meeting with building regs on the 2nd of July 2014, which would run till 3 p.m, and that you would join the group after that meeting. And that, of course, didn't happen in the end. You turned up at 2 o'clock at the start and left at some point during the meeting, yes?
Yes.
So it must be the case, I think, that you'd sent this email to Neil Smith before attending the CWCT meeting, yes?
That's how it seems. I'm sorry if I've incorrectly put something in my statement. That was not deliberate.
No, I understand that. I'm just trying to get the facts clear, because it leads to this question. What was it, if not the meeting, which it can't have been, that led you to send this email?
I can't remember.
Who were the few folk that you'd been talking to recently about fire safety and facades?
I'm sorry, I really don't understand.
And who are the relatively reliable sources that you say you received this information from?
I can see why you're asking me that question. Perhaps I'd had a telephone conversation with somebody. I don't remember.
Right. And you say that the sources are relatively reliable. What do you mean by relative? Relatively to what?
It looks like I'm being deliberately vague.
Yeah. Let's see if I can help you a little more. Can we go to CLG 3031777? It looks from this document, which is an invitation from Charlotte Robin at Arup to you and others, including Debbie Smith at BRE, to come to a meeting at Arup on the 25th of June 2014, so a week before the CWCT meeting and the email you sent that morning. And you say this, or she says this, as discussed, this meeting is intended to discuss some particular issues we come across related to interpretation of the performance requirements and how this is being achieved in real building applications. This covers multiple aspects of the fire/facade interface, including the use of combustible materials and fire stopping. Attendees, Debbie Smith, Brian Martin, Barbara Lane, Charlotte Robin, Neil Butterworth. Kind regards, Charlotte. Do you remember whether that meeting took place?
I have a feeling I may have merged two meetings in my memory into one. I see that Neil Butterworth is listed there. As I recall, I recommended to CWCT that Neil Butterworth was invited to the CWCT meeting. So I imagine I'd been speaking to the people at Arup on the same subject. So that would make sense. I'm sorry, I didn't remember this meeting at all.
Right. Okay. Does that tell us that the people you've been speaking to recently who are relatively reliable as sources were those at this meeting?
That would make sense.
And it was at this meeting that the concern had arisen that some people thought that it was acceptable and within the scope of ADB to put combustible insulation on walls above 18 metres.
That would make sense.
Right. Debbie Smith told us in her evidence that she recalled a meeting at Arup, but she couldn't remember you being there. But she does remember discussion about the definitions of non-combustible and limited combustibility. And she said that at day 237, page 74, lines 7 to 10. But does that help you with your recollection about the topics of discussion and the source of the friendly warning email information?
I wish I could remember in more detail. As I've a feeling I've got two meetings in my head that I probably thought were the same meeting.
Right. All right. So can we leave it like this then? Would you agree that it is likely that the source of the information you put into your friendly warning email on the morning of the 2nd of July was derived from what you'd learnt the previous week at the meeting at Arup?
It seems plausible.
Yes, all right. Now, going back to the friendly warning email, if we can, please, NHB 50712. You say in the second paragraph, second sentence, again, allegedly many of these buildings are blocks of flats. Did you have any rough idea how many buildings had been clad in combustible insulation above 18 metres?
No, none at all. It's always difficult to separate out when people say this is a big problem. You never quite know. They don't necessarily really have any evidence to say how big a problem is. They can only comment on the things that they've seen themselves. So I would have had no idea how many buildings there were, nor would anyone else.
Right. Did you not ask them for some examples of buildings, types of buildings, location?
I might have done. They probably would have not been willing to share that kind of information.
Did you not think to ask them how they knew what they knew?
I can't remember the meeting enough to know what I did or didn't ask them.
Right. Now, in your email, you refer to PIR specifically. Did you mean PIR or did you mean combustible insulation material more generically?
I don't know. A PIR of the foam insulations, there's a kind of hierarchy in terms of fire performance. PIR's at the better end, so it might be that's why we've flagged that, because people thought it was a better material.
Right.
Certainly, when you talk about we spoke yesterday, I think, about the insurance industry's provisions for sandwich panels in industrial buildings. And it was the panels that used PIR as an insulation, as I understand it, that were getting the best performance in those tests and in that scenario. Right.
So you were referring to PIR specifically, deliberately, rather as opposed to PUR or phenolic.
The fact that I've used PIR in there, I don't think I would have done that unless that's what I meant. I don't know.
Right. But might you not have meant it in, as it were, the family sense, which is the sense in which I think it was understood by NHBC, namely combustible plastic foamed insulation?
It could have been either.
Right. Did you know at the time that one of the combustible insulation products then being used on buildings above 18 metres was Kingspan's Cooltherm K15, which is of course not PIR but a phenolic foam?
I didn't know that at the time. I don't think.
Didn't know that then. You refer in the second paragraph, second sentence there, to people. Apparently people are under the impression that PIR is a material of limited combustibility. What people did you think were under that impression? Who were the people?
Oh, I haven't got a clue. I mean, I'm obviously... This is me fishing, I suppose, for want of a better term. Try and, in response to something I've heard, I'm trying to see what I can find out.
Yes. I mean, you say, which it isn't in brackets, I mean, can we take it that your view at the time, fishing or otherwise, was that it was squarely incorrect to think that PIR was a material of limited combustibility?
Absolutely.
I mean, it's first week fire safety, isn't it?
I don't know if it's first week, but it's something I'd expect anybody. Certainly, I would expect a building control officer to know that if they see a foamed insulation, it's not a material of limited combustibility.
Right. Now, you describe your email, or the purpose of your email rather, as a friendly warning. Why friendly? Why were the NHBC your friends, so to speak?
Well, I think Neil Smith at the time was a member of BRAC, which is probably why I was using him as a contact, because I had good contact details with him. I think, as I said before, is we can't actually tell building control bodies what to do. The judgments they make are their own responsibility. So I think I'm, in a roundabout way, I'm making it clear that I'm not telling them what to do. I'm asking them for some information.
Right.
I guess that's why I phrased it that way.
Did you have any other friends whom you thought deserved a warning?
I could have done the same thing with somebody at LABC.
Right. But why the approach? Why the finger tap on the nose approach to friends on the basis of what you had characterised as an unverified rumour? Why not get to the bottom of it first?
That's what I was trying to do.
Did you contact any other approved inspectors about this problem?
No, the way I looked at NHBC is significantly larger in terms of the amount of work it does than any other approved inspector. Specialises in house building, and it's just a big organisation, so it had a lot of resources, so that it was a way of getting a feel for what was going on over a broad area.
That I follow. I understand that. But my question is really directed at others. For example, did you contact any local authority, building control department, or the LABC?
No, in retrospect, I think I should have contacted LABC.
Did you contact the BCA?
The BCA doesn't have a kind of permanent contact. Not that I had an easy contact list. This was somebody I could contact quickly and easily, and I knew Mr. Smith reasonably well, and thought it would be a constructive thing to do.
Did you contact anybody in the design part of the industry, architects, designers, the RIBA? You've not seen any record of that?
No. I mean, this is the only contact I made was with NHBC.
Why? Why was this the only contact, given what you discovered from the BRE?
I think it was an email that I sent quickly, probably because I knew that I was. Now looking at it, I had a meeting with CWCT in the afternoon, so I'm trying to quickly gather some information about what's going on.
Right. So you didn't think about contacting, for example, the Construction Industry Council, CIC, or the RICS, or any other bodies?
I don't think I wouldn't have got a quick and simple answer from any of those organisations, whereas I think I thought I would do from NHBC.
Well, to be fair, you didn't get a quick and simple answer from NHBC either, did you? As we'll come to. But what were you after? Why would you expect a quick and simple answer? Here you are tipping off NHBC about a potentially very serious problem. Why not tip off other organisations who would have other avenues and reach a wider audience?
I think at this point this was more about me fishing for information than just alerting them to a potential problem.
And why did you not also, after you received the minutes of the CWCT meeting of the 2nd of July, later that day, the meeting being later that day, and you later getting the minutes, at that point alert the NHBC to the issue of the use of ACM panels with a PE core, which was the subject of discussion at that meeting?
I think at the time I lumped all of the issues together as just being, what's going on with cladding.
Well, that's a bit broad, isn't it? Here it's quite a specific point. PIR insulation over 18 metres, that's a very different topic from ACM panels with a PE core being used despite 12.7.
Yeah, but you were asking me about later on. This is before. Now I know this is before the CWCT meeting. So
Yes.
I'm guessing the ACM question hadn't arisen at that point.
It hadn't arisen at 11:42 in the morning. That's the point. The point is that once you'd seen, maybe try this differently. Maybe you've misunderstood my question, and it's my fault if you have. Once you'd seen the meeting minutes for the 2nd of July meeting, why do you not give another friendly warning number 2 to the NHBC, that it was possible that out there were ACM panels with a PE core, on the basis that some people might have misunderstood paragraph 12.7 of approved document B?
I don't know why I didn't do that. I think it just didn't register with me at the time.
Right. It didn't register. I mean, was there some difference in your mind between the importance of these two matters? On the one hand, the use of combustible insulation over 18 metres, as against, on the other, the use of ACM with a PE core over 18 metres?
I think you're crediting me with more consideration than I think I had time to give it at the time. As I said, with the CWCT meeting, I had to leave halfway through to go and brief a minister, I think on a completely different subject. That's probably what was on my mind at the time.
Can we then go, please, to CLG 50686? And this is the NHBC's response of the 11th of July to your friendly warning email of the 2nd of July. It comes from Steve Evans on that date, 11th July, to you, copy to Diane Marshall and Neil Smith. Dear Brian, and I'll read this to you. He says this: I hope that you are well. Neil Smith has discussed your email with me below and asked me to respond, as I have been dealing with this on behalf of NHBC. This is an issue that NHBC are aware of and have been in discussions with industry about it for some time. The issue is in respect of the use of Kingspan Coolfoam K15 rain screen board in buildings over 18 metres in height. The confusion has arisen from Kingspan's statement that their product is acceptable for use in a building over 18 metres. However, the product is made from a generic type of polyurethane foam, which is by nature combustible. Now, pausing there, you'd said in your email on the 2nd of July, the friendly warning email, which is also in this string, and we can look at it if we need to, that you said, I have no idea how true these allegations are. Do you remember that?
Yes.
Yes. Now, I just want to be very clear. Is it your evidence that as at the late morning of the 2nd of July 2014, you had heard a rumour, perhaps from the BRE, that combustible insulation had been or was being used on buildings over 18 metres in height, but you had no hard evidence to support it?
Yes, I guess so.
Yes. Were you unaware, therefore, until you read that paragraph of Steve Evans's email, that there had been discussions going on for some time between NHBC and industry, and in particular Kingspan, on this very subject?
It did come as quite a surprise. Yes, I wasn't expecting an email like this in response.
Right. And therefore, after seeing this email, you now knew that it was true that some people were either under the mistaken impression or knew very well that PIR insulation was a material of limited combustibility, but were nonetheless using it over 18 metres.
I think this email suggests that the issue is more complex than that.
Well, answer my question, please, if you would. Did this email bring home to you what you had not known before, or had evidence to support, which was that it was in fact true that some people were either under the mistaken impression that PIR or phenolic insulation was a material of limited combustibility, or else knew it very well but were nonetheless using it above 18 metres?
Yes, it
Yeah.
showed that a insulation that didn't seem to meet approved document B was being used in places where the approved document would say you shouldn't use it.
Yes. Now, let's go back in time. Let's go back to 2009, LABC 40924. This is a letter sent by a gentleman called Larry Cody of Rockwell to the LABC on the 25th of September 2009. Now, the letter's undated, but we can date it from Mr. Cody's follow-up letter I don't need to show it to you, but it was LABC 2018744. Now, I'm not going to read the whole letter, but I want to look at the bottom of page 2, if I can, please. Well, sorry, I'm so sorry. I do apologise. Can we go back to page 1? I want to show you, first of all, the first paragraph. He says there, we've been made aware of the attached article/newsletter currently appearing on the website of the insulation manufacturer Kingspan, entitled First to Make the Grade with LABC, which relates to its K15 phenolic plastic foam insulation product. This article asserts that LABC has stated the K15 can be considered a material of limited combustibility and, quotes, is suitable in all situations, shown on diagram 40 of approved document B volume 2, including those parts of a building more than 18 metres above ground, close quotes. This claim is of serious concern. Now, let me just show you page 2 at the bottom. If we go to that, we can see there that a copy of this letter was sent to you, yes?
Yes.
Then going back to page 1, when you received it, as I've just shown you that you did you read this letter?
I don't remember seeing this letter.
You don't remember seeing it? Do you not remember seeing that first paragraph?
No.
Right. Do you not remember reading the article?
No, I've since seen, I've had this letter shown to me since then in preparation, and
Right.
I don't remember having seen it before. As you say, it was copied to me, but addressed to LABC. I think I did ask the team back in the department to see if we could find any record of it, and we couldn't.
Right. Well, the fact that you couldn't find a record of it is one thing, but I don't think you can you deny receiving it? Even though you can't remember it?
I mean, I don't know whether it would. It looks like it was perhaps a paper letter, and as I say,
Yeah.
in which case probably the file would have been destroyed by now. I don't know.
Well, that may be, but at the time it would have. There's no reason, is there, to think that it wouldn't have come to you in the ordinary course of the way things were done?
I would have expected it to. Yeah.
Yes, and therefore, can we expect you to have read it when it came to you in the expected way?
I would have thought so. As I say, I don't remember it, and I suspect I would have seen that it was an issue where, in hindsight, it sounds awful. I would have seen that it was one manufacturer criticising another one and raising it with a body that wasn't the department, and I would have looked at it and said, well, that's a local authority building control issue, that we'll leave them to deal with it.
Well, leaving aside Mr. Cody's motives, one manufacturer criticising another, what he's doing is raising with the LABC the question of how it could make the statement that it did, namely that K15 as a phenolic insulation could be used in all situations shown on diagram 40. And on its face, if that is what the article states, or rather that is what the article says that LABC states, that's a very serious allegation, isn't it?
Yes.
Yes. Were you not interested to understand, never mind Mr. Cody's commercial motives in raising it, of course he might have plenty, but did you not want to get to the bottom of how on earth it could have come about that an organisation like the LABC could have made that statement.
I wish I had. I didn't at the time. The way our team operated is we didn't act as policemen for the system, and we would have left LABC and Rockwell and Kingspan to resolve this amongst themselves.
Well, you say you didn't act as policemen, but the government's job wasn't it, to make sure that its regulations and the guidance of how to comply with its regulations was understood by everybody, and that those certifying bodies, certified and approved by UCAS, who provided public statements, particularly in the area of fire safety, were doing their job.
Well, I think the LABC scheme isn't certified by UCAS and never was. My recollection of when LABC started, it moved from a sort of type approval approach to a kind of product certification activity, and some of the other certification companies were concerned about the fact that it wasn't UCAS accredited. And I think LABC decided to ignore that and carry on. So I can only say is the way that the Building Act was drafted was with the intention of minimal intervention by government, and we weren't really set up to do this kind of chasing role. On another day, I might have read this and maybe contacted Mr. Turner and asked him what was going on. But I clearly didn't do that, and I wish I had.
But just to be clear about your evidence just now, you're not saying, are you, that although you received this letter, your view at the time was that its contents had nothing whatever to do with government and were not a matter of public interest? I don't think you're saying that.
It's not, it wasn't our specific job to police the system, but if I'd have registered this, it would have not been unusual to contact Mr. Turner and say, what's this all about? I've no idea why I didn't.
When you say it's not our specific job to police the system, surely it was your specific job to make sure that the system was well understood universally and commonly, and to identify any defects in its operation in the public interest. No?
I think I would have been concerned if there was an issue with the guidance in the approved document, but I don't think that was the issue here. I think LABC had made a decision which Rockwell were disputing.
Can I take it that you don't remember discussing the matter with Paul Everall, who was the chief executive of LABC, or with any seniors in your department, Mr. Bird perhaps at the time?
No, so I don't remember the letter.
In or after May 2009, had you had any contact from Sarah Colwell or Debbie Smith or Stephen Howard or anybody else at the BRE about the content of the LABC certificate for K15?
Not that I remember. I don't remember anyone else mentioning this.
Right. Let's go back to Mr. Evans's email then, please, on the 11th of July 2014, back at CLG 50686. And I'd like to pick it up with you at the second paragraph, where he says this: the issue is in respect of the use of Kingspan cooled therm K15, and I've read to you down as far as 18 metres, and then picking it up in the second line, he says this: however, the product is made from a generic type of polyurethane foam which is by nature combustible. However, since 27th of October 2008, the product held a BBA certificate attached which indicates that it is acceptable for use in accordance with approved document B, Volume 2, paragraph 12.7, 7.1, subject to advice being should be sought from the certificate holder, 7.2, if the building exceeds 18 metres in height. It was on this basis that NHBC Building Control and other building control bodies accepted the use of K15 in buildings over 18 metres in height, including blocks of flats. We understand that LABC have also issued a registered detail approving the material for use over 18 metres. And then in January of this year, we were made aware of a revised BBA certificate for K15 issued on 17th of December 2013, also attached. The new certificate removed the passage which indicated that it was acceptable for use in accordance with approved document B, Volume 2, paragraph 12.7, and instead states that the product will not contribute to the development stages of a fire, but that it has only been tested and is therefore only suitable for one specific construction on masonry walls, 8.2. As we had a number of projects under construction and in advanced stages of design utilising K15, NHBC approached Kingspan and made them aware of our concerns. As a result of this dialogue, Kingspan are currently undertaking further testing using different cladding and facade treatments in accordance with BS 8414 Part 2 2002. The results from the tests are expected by the end of this month, and NHBC are meeting with Kingspan at the beginning of August, at which time Kingspan will be asked to provide evidence that their product can be used in alternative construction types other than that specified in the current BBA certificate. And then he says this, over the page at page 2, there is no reason to suspect that buildings which have been built with Kingspan K15 are at risk at this time. It is just the fact that the testing carried out to date does not bear this out. Kingspan are confident that the testing currently underway will prove the suitability of the material for use over 18 metres. If they're not able to do this, we will begin the process of informing industry that the product is no longer suitable for use in facades over 18 metres, as well as informing other stakeholders, such as BCA and the Fire and Rescue Service, although both parties are already aware of our ongoing discussions. I trust this addresses your immediate concerns, etc. And you can probably see that Mr. Evans attached to the email were two BBA certificates for K15, the one from 2008 and the one from 2013. Let's just have those up on the screen one at a time. The first one is CLG 50688. And you can see it there with the date at the bottom left-hand corner, 27th of October 2008. Amended on the 6th of April 2010. Do you remember looking at that at the time?
I think so, yes.
And then the second one, CLG 50687, which was the one revised on the 17th of December 2013. Do you remember reading that one at the time as well and comparing the two?
I believe so, yes.
Yes. Did you notice that the earlier certificate sent to you was an amended certificate dated April 2010 and not the original from 27th of October 2008?
Not that I remember. I might have done.
Right. It's in tiny text at the bottom of a light grey box. I should go back to that, in fairness to you. CLG 50688. There. Very small letters underneath the date. Certificate amended on 6th April 2010. Do you see that?
Yes.
Did you notice that at the time, do you think?
I couldn't say.
Right. Now, if we go please to page 5 in that certificate, let's look at it. Section 7, behaviour in relation to fire. Did you read that section of this certificate?
I'd be surprised if I didn't.
Yes, indeed. And it says there, England and Wales, approved document B, paragraph 8.4, volume 1, and paragraph 12.5, 12.6 and 12.7. And that is preceded by the words, the product may be used in accordance with the provisions of. Do you see that? And the reference to 12.7, did you notice that at the time?
I guess I must have done.
What did you think when you read that?
I can't remember what I was thinking at the time, but I wasn't very happy with it.
must have been an understatement, Mr. Martin.
Yeah,
You must have realised immediately that it was a fundamental error to call a clearly combustible foam insulation something which could be used in accordance with 12.7.
yeah.
Yes. How concerned were you about that when you read that?
Quite concerned. So I raised this with Mr. Leadsom and Mr. Harrell because I was concerned that there was a significant problem here.
Yes, you did, and we'll come to that later. Did you notice... well, let's look at the revised certificate. If we go to CLG 50687, this is the revised certificate from December 2013. If we go, please, to page 6, section 8, paragraph 8.2, when tested to BS 8414 Part 1 2002, the following specific cladding construction met the criteria stated in BR report BR 135, and then it sets out the details of the system tested. You see that there. Did you notice that there was a reference to the one test carried out on a system incorporating K15?
Yes.
What were your thoughts on that?
It's one test, so you wouldn't be able to use that in a general way.
Right. So what did you think of the certificate and the ability to use K15 above 18 metres?
The certificate's wrong.
Yeah. And if we go to page 1, please, and the section headed Key Factors Assessed, and you see that under the third paragraph it says behaviour in relation to fire. The product will not contribute to the development stages of a fire or present a smoke or toxic hazard. What did you understand that to mean?
That's a pretty meaningless statement to me. It's not a phrase that it's not a classification that I would recognise.
Right. Did you think to go back to, when you saw these two certificates, the first with a plainly erroneous reference to 12.7, enabling use above 18 metres, and the second with only the single 8414 test and a meaningless expression on the front page in relation to behaviour in relation to fire, did you not think to go back to Mr. Evans straight away and say words to the effect of these two certificates are so much waste paper, you should be extremely concerned?
That wasn't the thought that came to mind. The impression I got from NHBC is that they recognised they were a problem and they were working on trying to resolve it.
Did you think to raise these problems with Mr. Alban of the BBA when you contacted him, as we can see you did? We'll come to the correspondence after the break.
Not directly. I didn't raise those particular points with him, no.
No. And if we go back to your statement, we'll just look at this before the break. Please, can we go to page 43, page 124? You say, on the basis of what Mr. Evans told me, I was satisfied that the appropriate steps were being taken by NHBC in their capacity as both the largest body of approved inspectors and a leading provider of warranties and insurance in the house building sector, but I asked him to keep me informed. I contacted Richard Harrell and Bob Leadsom on the same day to alert them to the issue. You say that. Now, on the 11th of July, even when you learnt directly from Mr. Evans that not only the NHBC but other building control bodies had been accepting it in K15 for use over 18 metres on the basis of, it seems, the 2008 BBA certificate, you still didn't contact any other building control bodies, did you?
I think because I think in his response to me, he said that they were talking to the other stakeholders like the Building Control Alliance and Fire and Rescue Services. So I took the view that NHBC had taken leadership here.
Why have they taken leadership? Surely it was for you to take, government to take leadership.
NHBC would be able to react so much more quickly than we would. We were a tiny team with. I can't press a button and suddenly instigate a major investigation. That's something that would take months to get off the ground. It was clear that NHBC had been looking at this issue for a while and had been including other stakeholders. And at that time, we were very busy on another project, so I saw NHBC taking the lead as being a positive thing, and that really tied in with the way we'd come to work over the years, in that we were encouraged to work with industry or use industry bodies to resolve problems where we could.
What was the project that you were busy on that meant you couldn't instigate even the most cursory kind of investigation as to how the BBA could have issued these two certificates?
I think it was the Housing Standards Review was probably the main thing that was going on at the time in 2014.
Right. Mr. Chairman, I'm looking at the clock. Is this a convenient moment?
Yes, I think it is. All right, Mr. Martin, we'll have a break at this point. We'll resume please at 25 to 4. And again, have to ask you not to talk to anyone about your evidence while you're out in the room. All right, would you go with the usher then, please?
Yes, sir.
Thank you very much, Mr. Millett. 25 to 4, please. Thank you. Well, Mr. Millett, if you're ready to continue, perhaps you'd ask the usher to invite Mr. Martin back.
Yes, Mr. Chairman, I am, and I'm going to. Mr. Martin, if you could please be brought back into the hearing room, please. Thank you.
All right, Mr. Martin, you ready to carry on?
Yes, sir.
Good. Thank you very much. Yes, Mr. Millett, when you're ready.
Yes, thank you. We were on CLG 50686. If we can please have that back up on the screen. CLG 50686. Yes. And you, I read the whole thing to you, and you'll remember in it that he describes a process of informing the industry that the product, K15, is no longer suitable for use in facades over 18 metres. And that's, just to pick it out, on page 2, paragraph 5, it's not numbered, but the 5th paragraph down, 3rd line. See that? Sorry, 5th line. If they are not able to do this, we will begin the process of informing industry that the product is no longer suitable for use in facades over 18 metres. That doesn't make any sense, does it? No longer suitable for use in facades over 18 metres.
I think the point they're making is they'd been convinced by Kingspan that evidence would be produced that demonstrated that.
Well, a reason I'm suggesting, I'm so sorry. The reason I'm suggesting to you it makes no sense is because Kingspan K15, a phenolic foam insulation, was never suitable for use in facades over 18 metres. The only use over 18 metres it could ever be deployed in is in a system which had passed the BR135 criteria after an 8414 test.
Yes, and I think the point that NHBC are making is that Kingspan were going to retrospectively carry out some tests to demonstrate that it was okay.
But was okay for what?
For the way it had been used.
That's not possible, though, is it? I mean, you can't demonstrate that it's okay for the way it had been used unless you replicate each and every facade system precisely and then subject it to a BS8414 test and then measure the results of that test against the BR135 criteria.
You'd certainly need to do a lot of tests, which I think is what they're proposing. I don't think... I think there's a presumption here that a lot of the buildings would have very similar constructions.
Well, you say there's a presumption here. Was that the way you read the email?
Yes, I think it was the way I read the email that they would carry out a number of tests in order to satisfy themselves and HBC that the way it had been used or the way it was proposed to be used was still acceptable.
Right. I mean, I just want to try and get your understanding of what you're being told by Steve Evans. They're taking it in stages. Do you accept that as a phenolic foam, it could never meet ADB through the linear route?
Correct.
Because it was never going to be and had never been a material of limited combustibility?
Yes.
Yes. Therefore, do you accept that the only way it could meet the guidance would be through the alternative, which was passing the BR135 criteria, having undergone a BS8414 test on a full system, yes?
Yes.
And do you also accept that here we are now in July 2014, about a year after the publication of BR135 third edition, which had made it crystal clear in both annexes that the results of a BR135 test could only be used on the precise system as tested and were not transposable? Yes?
I see your point. I think there's a difference between claiming a classification and so you can only claim a system has passed a test and achieved a classification if you're referring to that specific system.
Yeah.
But and I think this was the evidence that Dr. Smith gave, which I agree with, if you had a number of tests which you were able to interpolate between, you might be able to satisfy yourself that a system that sat between two designs was acceptable, but you couldn't classify it but you might consider it still to be safe. And I think that's what NHBC and Kingspan were trying to do.
Well, how do you get that out of this email?
I'm probably reading between the lines.
Right.
Mr. Millett, can I just break in for a moment?
Yes.
I need to be a bit careful not to spend too much time on linguistic niceties in some of these messages. Like you, when I first read that message, which has now disappeared from my screen, I'm afraid, I thought, well, that's nonsensical as well. But then I thought that perhaps it was intended to be read as informing the industry that the product is no longer considered suitable, although in the past it had been considered suitable. And that's why they used the expression no longer suitable, which is a bit elliptical, but might explain it.
Right.
See?
Yeah, I see the point you're putting. I think if you're putting the point to me, Mr. Chairman, I see that, but I can only go on what I've got on the screen, and trying to elicit Mr. Martin's evidence about what he read at the time. But let me pursue that with that qualification. Just in what we see, would you accept that there's no possibility that Kingspan could ever have been previously suitable for use over 18 metres, but was no longer suitable because of changes to a third-party certificate? Yes?
That would be how I would have applied the building regulations, yes.
If the new BBA certificate was right and accurately made it clear that K15 was not suitable for use over 18 metres in a generic manner, then that would also have been the case before the issue of the revised certificate, wouldn't it?
Yes.
And further testing on specific systems under 8414 couldn't make K15 suitable for use in all facades over 18 metres in a generic manner, only for those specifically tested. Yes?
Certainly not in a generic manner. As I say, you might well find you've got 4 or 5 buildings which have got very similar constructions, which would seem quite plausible.
Right.
And you might do 2 tests to look at the extremes and then interpolate between. That might be a reasonable way of addressing this question.
Yeah. No.
That's what I assumed they were doing. I'm not sure why I assumed that, whether it was just from reading this email or whether I'd spoken to Mr. Evans, I can't remember.
Right.
But that was my understanding of what they were planning to do.
So a desktop, for want of a better word.
Yeah, and I mean, I've always called them assessments in lieu of tests, but for some reason
Right.
the cladding world started calling them desktop assessments.
All right. But so long as we understand each other.
Yes.
An assessment in lieu of a test. So that's what you understood. And did you understand that because you knew, first of all, that a revised BBA certificate could not make a previously unusable, a previously usable combustible insulation above 18 metres unusable? And secondly, that the Kingspan were not about to do thousands of tests to replicate each and every one of the systems in which K15 had made a previous appearance.
Yes, I mean, I didn't know how many buildings there were, but I got the impression that
Right.
there were a lot, and you wouldn't expect, it would seem unnecessary to test
Right.
every configuration. But I was expecting them to have to do quite a lot.
I understand. Now, in paragraph 123 of your statement, we don't need to look at it, but let's look at the quotation from the document itself. At the very top of your screen, Mr. Evans says, "There's no reason to suspect that buildings which have been built with Kingspan K15 are at risk at this time. It is just the fact that the testing carried out to date does not bear this out." What did you make of that statement?
I think they're making the point that they thought that they'd obviously been convinced by Kingspan that the testing would demonstrate that there wasn't a problem. In the run of things, phenolic foams are probably the better performing foam insulations amongst the different foams that are available. Well, that was my understanding at the time, anyway.
How did you understand that if a system containing K15 was tested under BS 8414 but didn't meet the BR135 criteria, it nonetheless presented no risk if used above 18 metres?
I'm not sure I understand the question. I didn't think that's what I said.
Well, how could failed tests or no tests not present a reason to suspect risk?
I guess we didn't know one way or the other, but NHBC were convinced that this was a problem that would be resolved once the testing had been carried out.
I mean, that first sentence is difficult, isn't it? And the reason I ask you that is this. Surely the fact that the testing carried out so far did not support the use of K15 in more than one very specific build-up, which had been identified, did mean that there was a risk if K15 was used in different and untested build-ups.
I think there's a risk. You don't know what the risk is, and so that in itself is a risk, I suppose.
Yes, precisely so. And
Well, with respect, Mr. Martin, I'm sorry I keep butting in this afternoon, don't I? It's a nonsensical statement, isn't it? Because you're starting from the proposition that K15 is not of limited combustibility. And the fact that it's not of limited combustibility is a reason for thinking it's unsafe for use over 18 metres. So the absence of any testing to show that it is safe leaves you with the understanding that it's not safe. Isn't that right?
I suppose at the time we were thinking, or Kingspan and NHBC had taken the view that they'd had one successful BS 8414 test, and so there was the potential that they'd have another one, and that seemed plausible to me at the time.
Well, they'd had one successful test on on a wall structure, which, as far as we know, was not typical because it was a masonry substrate.
I don't think I thought about that at the time. So I think the substrate's probably less critical than the layer. So we're talking mostly about rain screen systems here. With the BS 8414 test, a significant part of the success or failure of the system is whether the rain screen shields the insulation from the effects of the fire. And that will be more or less successful as a combination of the resilience of the rain screen and how readily the insulation burns. So it seemed plausible to me at the time that they may well get more passes via an 8414 test if they carried out some more tests. So it seemed a reasonable starting point to me at the time.
I quite see that if they did more tests and if they got passes, that would tell you something about the systems in which K15 could safely be used. But that's as far as it goes, isn't it?
Yes, I mean they should. This wouldn't have been a reason to continue using it until such time as they concluded that, having identified the problem, I wouldn't have expected anyone to be continuing to use it.
All right, thank you very much.
Right.
Sorry.
No, that's quite all right, Mr. Chairman. And following from that, the question is, why didn't you challenge Steve Evans on this precise point and tell him that unless and until K15 was being used in exactly the build-up tested as described in the December 2013 BBA certificate, there was a historic and likely widespread non-compliance with ADB and very much a risk that the functional requirement had not been met in respect of those buildings?
I got the impression he understood that.
Well, forgive me, but the sentence with which the chairman has just been concerned tells you the precise opposite. He had completely failed to understand that. Well, otherwise, he was spinning you a line.
I believed at the time he was convinced that when they carried out a series of more BS8414 tests, they would get successes, and therefore sort of retrospectively going back to the buildings that they were working on and that were already in hand wouldn't be necessary. So I think that's what I understood at the time. Is he was convinced that it would be shown to be fine, and he was sufficiently confident of that he felt that there wasn't necessarily an absolute risk. I can see that, in fact, you couldn't be sure one way or the other at this point.
Yes. In fact, yes, but it's worse, isn't it? In your last answer, you said, going back to the buildings they were working on that were already in hand. Now, this is about buildings, as he says, which have been built. In other words,
yes,
the historical legacy of buildings containing K15 above 18 metres. Why not go back to him and say, unless and until you can confirm that each and every one of the buildings which have been built pass at the BR135 criteria on exactly that same structure, there is a very real risk to that building population. They contain combustible material in their external wall build-ups over 18 metres.
I don't think... I'm not sure I fully understand the point you're making. I saw this as a reasonable approach to the problem that they'd come across. There were a lot of buildings where they'd used this insulation, and before taking action, which might have needed to be quite substantial, they needed to be sure one way or the other what the problem was.
Well, you say a lot of buildings where they'd used this insulation. Just tell me, what would have retrospectively had to be done in order to ensure that those buildings which had been built using K15 were safe, were compliant?
They needed to carry out a series of BS8414 tests and satisfy themselves that there wasn't a hazard.
And satisfy themselves there wasn't a hazard by reference to the results of each and every BS8414 test?
Yes, and as I say, I expected they would probably interpolate between some of the tests. I didn't think you'd need to carry out a test for each building, but you'd need to carry out quite a few, and that was the impression I got. That's what they were planning to do.
When you say quite a few, 2, 3, 4, 6, or hundreds?
I was thinking more than dozens. Certainly more than a dozen. That I don't know where I got that number. That was just what I imagined, given what they'd said to me.
Right. Why didn't you pick up the phone to Steve Evans? After all, the NHBC were your friends, and just ask him what he meant, and say, well, what's the testing programme planned here? We've got a legacy of buildings with K15 over 18 metres. There's a problem here. What are you expecting Kingspan to do? I know you didn't do that, but why didn't you do that?
Don't know. I know I'd spoken to them at some point, but I can't remember when that was in the timeline. Perhaps it was later on.
And what about the people living in these blocks? In the meantime, did you think about them?
I guess I was worried, but I at the time, I thought this was the best approach.
What? There's no reason to suspect that buildings built with K15 but untested presented no risk to life safety in those buildings? You thought the occupants of those buildings were safe?
I thought that was the best available answer that we'd have.
Now, in fact, you say in your statement that you escalated this. You contacted Richard Harrell and Bob Leadsom the same day to alert them to the issue. You say that in your statement at para 124. We don't need to look at it. Let's look at the email. CLG 50686, please. And what you do is you send Steve Evans's email to you on 686 top email, sorry, page 1, I'm sorry. Thank you. Here you can see you sending the email on to Richard Harrell and Bob Leadsom the same day. You see that?
Yes.
Richard, Bob, see below. It would appear that a number of tall apartment buildings have been insulated using combustible insulation materials when perhaps they shouldn't have been. This appears due to an error in a BBA certificate for this type of insulation. NHBC are aware and are working with the manufacturer to see if this is a problem or not. If it is a problem, some blocks may need to have their cladding replaced, possibly a lot of them. I've asked NHBC to keep us informed. Now, does that accurately reflect your view at the time, as expressed to Mr. Harrell and Mr. Leadsom?
Yes.
Yeah. Now, you say in the penultimate line there, if it is a problem, if it's a problem, surely you knew that it was a problem, because you had no reason to think at that point that each and every external wall system over 18 metres in which K15 had been applied had been tested and met the BR135 criteria.
As I say, the way we looked at this is we didn't know one way or the other. You'd have to. I mean, there wasn't a mechanism to deal with this. There isn't a what you'd have to try and come up with an approach for dealing with this, which would be difficult, and you might be having a really big impact on lots of people and for no good reason. And so at the time, we thought it was reasonable to let NHBC continue their investigations and work with Kingspan. As I say, if we'd had started something, it would have taken us months to get it off the ground. And NHBC had seemed to be at an advanced stage with this. So I think we spoke. I certainly remember speaking to Bob about this. I'm sure Richard was involved as well. And we came to the conclusion that probably the best thing to do would be to wait to see what NHBC found.
Now, on the 11th of July, you'd been told in clear terms by NHBC that K15 had been used on a number of their high-rise projects, and there was no test evidence to support that use. We've seen that. I'm interested in number there. What impression did you get of how many buildings, high-rise buildings, had been built using K15 over 18 metres?
I'm not sure I had a number in mind. I got the impression it was significant in the order of 100 or something.
Right. I mean, you say to Harrell and Leadsom, possibly a lot of them. Why didn't you ask NHBC precisely how many buildings their building control officers had signed off, or if different, how many warranties they provided under the Buildmark warranty in respect of these buildings? Give you an idea of the figures.
Didn't occur to us at the time to do that.
Did it occur to you that K15 might also have been used on an unknown number of similar projects where the NHBC had no involvement?
I think the view we took was to wait and see what NHBC found, and that would give us an indication of whether this was something, a major problem or not.
Well, yes, I'm asking something different. I'm not asking you about technical justifications retrospectively. I'm asking you about numbers. Were you not interested to know that if it was a problem, how big the problem was, even at that stage, pending Kingspan coming up with their tests that would cure it all?
It seems like a reasonable question to ask, but we didn't think of it at the time. I don't know why.
Is it because it was just unthinkable, and you had the makings here of a crisis on your hands that you simply couldn't conceive of?
I don't think it was that. I think it was just this was a potential problem, and we'd be getting more information soon. I think that was just the. That was the conversation we had. We looked at what we heard from NHBC and concluded that we'd sort of maintain the watching brief and see what they came up with.
And you said a moment ago to us that your figure you had in mind in rough terms was about 100 blocks, yes?
I think so. I've no idea why that number was in my head, but that for some reason that's the kind of scope that I was thinking.
Yes.
I don't know why.
But, I mean, that is tens of thousands, if not certainly thousands, of individuals, isn't it?
Yes.
So that's the life safety, the exposure to injury and death in fire of thousands of people. And it's a potential problem.
I think we accepted the point that NHBC made, that they took the view that this was probably not a real risk.
How come? You've got K15, a combustible material being used in the external wall build-up of possibly 100 blocks without being tested. How could that not be a real risk?
It seemed plausible to me at the time that.
But how? Sorry to ask with a degree of incredulity, but
no, I understand why you're asking, and I think it's a very fair question. I think the whole idea of the BS 8414 test was to allow this type of insulation to be used in the proper circumstances, and so it was plausible that this might just be an academic question rather than a genuine safety problem, and we wanted to see the evidence of that before we decided what to do.
You told us earlier that the BS 8414 test was a difficult test to pass, so...
Yes.
Yes. I mean, how could you have any confidence that Kingspan would, as it were, come up with the goods, at least with the breadth required in order to, retrospectively, to justify the use of K15 on possibly 100 blocks?
It's difficult to see back into your own mind, but I think it may have been because I'd known that they'd had at least one successful test.
Right.
So it was plausible that there'd be more.
Did either Mr. Harrell or Mr. Leadsom seek to discuss what you told them here with you after this email?
We did discuss it, yes.
And what was the upshot of that discussion?
I think I certainly remember speaking to Mr. Leadsom about it, and I think we agreed that we take the wait and see option and see what NHBC came up with.
So, do nothing and wait.
Yes, at that time, yes. Wait and see what NHBC found and then decide what to do from there.
Right. Wait for how long? How long were you going to allow this potentially extremely risky situation to continue before you acted?
I don't think we fixed a time at that point.
Now, you may have missed it when I read it to you, and I wouldn't be surprised, but do you remember that in his email, Mr. Evans told you that the LABC had also issued a certificate approving K15 for use over 18 metres? I can go back to it if you like.
Yes, yeah, I'm aware of that.
Yeah. Did you contact the LABC about that when you saw that the NHBC had referred to that fact in their 11th of July email?
No, I think because he says in his email that he was talking to the Building Control Alliance. LABC are a key partner in the alliance, so...
Yeah. Well, why didn't you go to them and ask them? How come? This is now turning into a widespread issue.
I think we took the view that the NHBC and by their communications with Building Control Alliance were addressing this. They're an organisation with a lot of resources and able to look into this and in a way that would have taken us a lot longer to make happen.
But you're the government. Well, not you personally. Well, you personally, in this sense, you're the government. You're the people who make things happen. You govern us. That's the point of view. I can't understand why you wouldn't immediately want to pick up the phone to LHBC, ask for the certificate, and interrogate how it could record the fact that a K15 could be used above 18 metres, in circumstances where you now knew that there were possibly up to 100 blocks, thousands of people at risk. Are you able to explain?
At the time, it seemed like the right thing to do.
Did you contact Kingspan at any time to find out why or how they were making the claim that Kingspan was suitable for use over 18 metres, as they had peddled on the basis of a clearly erroneous BBA certificate since 2008?
No.
Why not?
We decided to let an HBC take the lead on the issue.
Did you not ask or think of asking Kingspan to find out for yourself how they could help with how the claim that K15 was generally suitable for use over 18 metres got into not just one certificate and its sequential revisions, BBA, but a second certificate, the LABC certificate from 2009?
No, as I say, we thought the best thing to do was to let NHBC continue what it had already started doing.
Right. So you did nothing with no time frame for when you were going to intervene, and you left it to the manufacturers, the certification bodies, and the NHBC to come up with some kind of unknown and unnamed solution.
Yes.
Going back, if we can, to the email of the 11th of July, CLG 50686, Mr. Evans says this, and it's paragraph 2. I say it's unnumbered, but it's paragraph 2, line 4. He says, third line, however, since 27th of October 2008, the product held a BBA certificate attached, which indicates that it's acceptable for use in accordance with approved document B, volume 2, para 12.7, subject to advice, etc. And then the next sentence, it was on this basis that NHBC building control and other building control bodies accepted the use of K15 in buildings over 18 metres in height, including blocks of flats. I'm so sorry. Thank you, Mr. Ali. I apologise. Let me show you that again so everyone can follow it. I'm picking it up at the third line. Since 27th of October 2008, the product held a BBA certificate attached, which indicates that it's acceptable for use in accordance with approved document B, volume 2, paragraph 12.7, 7.1, subject to advice being should be sought from the certificate holder, 7.2, if the building exceeds 18 metres in height. And then it says, it was on this basis that NHBC building control and other building control bodies accepted the use of K15 in buildings over 18 metres in height, including blocks of flats. Now, looking at that, didn't it strike you as odd, to say the least, that the NHBC had apparently been relying for many years on information within a BBA certificate which was plainly wrong?
I think it was disappointing, but to some extent it reflected what had happened to the building control system throughout my career, really. When I first started as a building control officer, we were probably more difficult and looked for reasons to reject things. I think the nature of the market forces that had affected building control bodies meant that they tended to be more willing to rely on third parties to tell them something was acceptable than perhaps we would have done when I'd first started as a building control officer. So I think I was disappointed in that, that perhaps nobody in building control had questioned that certificate sooner.
Well, that's an answer to my question, but I want to see if I can just examine it a bit further. It's not just disappointing. Is it not shocking that the NHBC, the country's largest provider of building control services in the approved inspector regime and warranties, were routinely allowing a Kingspan K15 above 18 metres based on a certificate that was manifestly wrong? That anybody who'd looked or knew anything about the approved documents would know that the reference to 12.7 should never have been there.
I suppose shocking's a suitable word, yes.
And the fact that combustible insulation cannot, in fact, be used over 18 metres in accordance with 12.7 of approved document B appears to have escaped the notice of the country's largest supplier of building control inspectors for some 7 years. Were you actually shocked by that at the time, or just disappointed? There's a difference.
I can't tell you how I felt at the time. It's very difficult. This is, I imagine for everybody involved, this is very emotional. It's emotional for me as well. So trying to put myself back into my head back then is quite a difficult thing to do. I think at the time perhaps I was just disappointed, but it is.
Right.
It's difficult to say.
All right. I mean, taking the emotion out of it, did it cause you to consider that there may be a serious issue with NHBC's processes, with the quality of the people who are actually doing the job on the front line?
I think the problem was the willingness to accept a certificate without challenge, and I think there are a number of factors involved in that. As I say, I think part of that is the way the building control service had changed over the years, but also the history of BBA is that when back in it was probably the very early 80s, a BBA certificate was close to being sort of categorical. You know, it was linked to the building regs almost directly. I think the original intention was that there would be a reference to them in the regulations, but that never happened. And so they were regarded as being of a higher level than perhaps any other certificate. But that had changed over time, so that they had no. That they were just an independent certification body like any other, but I think a lot of people in the industry regarded them as having a special status, which actually they didn't have.
Did you realise at the time that the NHBC had taken the view, let me put this to you, but did you realise that they'd taken the view that even though the BBA certificate contained a manifest error, nonetheless they were bound to abide by it? Did you know that?
I don't think I wouldn't have recognised the. I'd be surprised if they said they were bound by it. You're probably going to tell me that is what they've said, because that certainly wasn't the case. But as I say, historically, they were close to that status, but things had changed, and BBA didn't have the same status they had in the 80s. So I would have hoped a building control body would have looked at that certificate and said there's something wrong here and challenged it.
Now, we know that you did contact the BBA the same day, in fact.
Yes.
So let's look at that. BBA 50178, please, page 3, bottom email. And it's an email sent by you to John Alban at 16:40 that day. Safety concerns regarding BBA certificate 08452. And you say this. I should just ask you, it's copied to Guy Bampton and Nick Price. And am I right in thinking that Guy Bampton was team leader in the Building Regulations and Standards Division at the time?
He was a team, so he was, I think, I'm trying to think, at that time, Guy was probably a grade 7, so the same grade as me, and one of the things he would have been dealing with was the sort of construction products regulations. And whilst that's not directly linked to BBA's certification business, BBA were connected in other ways with the construction products regs. So I think I was including him so that he was aware of what was going on. And I think at that time, Nick Price was helping him with that in some respects.
Right. And you write, "Dear John, I'm not sure we've met. I'm currently the official at DCLG responsible for Part B of the building regulations. It has come to my attention that BBA certificate 08452/2008 included advice that the product in question satisfied paragraph 12.7 of volume 2 of approved document B. Para 12.7 provides that insulation materials used in external walls should be materials of limited combustibility. It would appear, however, that the product in question is not a material of limited combustibility. I'm also aware that certificate 08452 has recently been revised and that this reference has been removed. I'm concerned that the original certificate may have been issued in error. As this is a serious safety matter, I would appreciate it if you could investigate and advise me of the outcome of your investigation as soon as possible. Could you please acknowledge receipt of this email?" Now, the error you refer to there was BBA's statement that K15 was a material of limited combustibility by reference to para 12.7, was it?
I think so, yes.
Yes, and I think you've accepted that's a pretty fundamental error on the face of the document. Is that why you described it as a serious safety matter?
Yes, I think I'm also using that language to make sure that they respond in good time.
Yes. And does your characterisation of the problem as a serious safety matter and the relative speed with which you took it up with the BBA, following Evans's email that day, tell us that in fact you were very concerned about what you'd learned from the NHBC about the BBA certificate?
I guess I was concerned about it, yeah.
Yeah. And if we go to page 2, please, next email up. This is John Alban's response to you on the 16th of July at 12:14, and he writes as follows. John, many thanks for your prompt response. I'm so sorry. It's the second email down. John Alban, thank you for your mail regarding the above certificate. The amendments made on 6th April 2010 to certificate 084582 included a new reference to paragraph 12.7 of approved document B. And then he says this was not intended to imply that the product was of limited combustibility and, as you have observed, was removed in the subsequent reissue dated 17th December 2013. Now, pausing there, whether or not it was intended to imply that the product was of limited combustibility, I think you would agree, wouldn't you, that that is exactly what the certificate expressly said by reference to clause 12.7, yes?
Yes.
Yes. And going on with his email, the reference, he says, to 12.7 seems to have been an unfortunate and rare oversight that would not escape the internal checks and measures that BBA currently operate. A review of other certificates has confirmed that this has not been reproduced elsewhere. And then he talks about the leader certificate system, and then goes on to say in the next paragraph, I've spoken to the BBA's chief executive, Mrs. Claire Curtis Thomas, regarding your inquiry, and we would be very willing to meet you at your offices to discuss the relationship between the DCLG and the BBA and how we can work more closely together. Would you please let me know whether you would be interested in such a conversation? And if we go to the top of the page, please, top of page 2, your email back to him the next day. John, many thanks for your prompt response. For completeness, I wonder if you could confirm a couple of things for me. First bullet, what has BBA put in place since the original certificate was issued to make you so confident this won't happen again? A summary would be fine. Will you be notifying the manufacturer, certificate holder, of the issue? I note your comment about the relationship with DCLG and BBA. I think things have significantly changed over the years, and my understanding is that your status is similar to any other certification scheme. I very much doubt we could support all the various schemes in the way you suggest. Why was a summary of the changes at the BBA fine?
I wanted something in plain English.
But why only a summary? Why not a detailed exposition of how this fundamental error could have come about from a UCAS-governed certification body?
I can't remember what I was thinking at the time.
Given that this was, in your own words, a serious safety issue, why didn't you demand a meeting or full details of how this fundamental oversight, as Mr. Alban had described it, could have occurred?
I didn't think that was necessary at the time. They'd stated that this was they reviewed all their other certificates and this was the only one where this occurred, and they'd rectified it.
Did you think of involving UCAS and asking them to investigate?
No, but I think I should have done.
Yes, why didn't you?
I think I should have done. I think at the time I thought that UCAS would have eventually. There's no kind of. They wouldn't have been penalised by UCAS. UCAS would have said, have you put systems in place to make sure this won't happen again, which they'd already said they would. So I think I decided not to. I don't really remember exactly what I was thinking at the time.
Right. I mean, do you accept that it's possible that UCAS, if they'd investigated, might have discovered some wider problems with BBA's processes?
Yes, and I think I was wrong not to bring it to the attention of UCAS.
Did you ask Mr. Alban whether the BBA itself had reported the matter to UCAS?
No, I didn't.
And was it your opinion at the time that the BBA ought to have done that?
I don't know if I thought about it at the time, but they should have done.
Were you concerned about whether UCAS inspectors themselves or the auditors had failed to spot this error as part of their spot checks?
That didn't occur to me at the time.
Right. Did you want or expect the BBA to tell Kingspan that NHBC and now your department knew that there were many buildings out there with K15 on them as a result of an erroneous and misleading BBA certificate?
I think the fact that there was an error is something they should have brought to the attention of Kingspan, yes.
Did you consider that Kingspan might be unaware that the BBA certificate for K15 contained the misleading claim that the product could be used in accordance with the provisions of 12.7 of the approved document?
I can't remember what I was thinking at the time, I'm afraid.
When you say in the last sentence, I very much doubt we could support all the various schemes in the way you suggest, why did you doubt that?
I think, as I say, when the BBA was first established, it had a connection with government and was intended to help the industry identify or assess construction products, but early on in its history, that approach had been, put to one side. I can't think of a better way of putting it. That wasn't the case anymore, and BBA had become a certification company of which there are a lot. There's maybe a dozen or so, and so the idea that officials in the department could work with them on their certificates on a regular basis, we just didn't have that kind of resources. It's for if you're operating a certification business, you need to have the resources to be able to produce reliable certificates, and that's what you should be doing.
Now, Mr. Alban responded to your email on page 1, if we go to that, on the 23rd of July 2014 at 7:17. If we go to that, it says 08:18, and he says, Brian, the mistake was basically caused by human error. The project manager involved and their line manager no longer work in the BBA's operations department. We are addressing the overall issue in 3 ways. We've introduced a new training programme for all staff, focusing on both technical and procedural matters. An additional level of checking has been introduced via a new management structure. We've placed more emphasis on certificate templates, which are commented on by internal and external experts prior to finalising, as referenced in my earlier email. There would have been dialogue with the certificate holder as part of the reissue process, and I would expect that this would have been pointed out. The certificate holder would not claim that the material is limited combustibility, and this has never been stated in the certificate, which did correctly give only a Class 0 rating. I think the chances of anyone inferring limited combustibility to be extremely unlikely from the certificate wording, and while the error is of course a concern, I'm pleased we recognised and corrected it. I would repeat my offer for our Chief Executive and I to meet with you to discuss this and any other issues that you may have if you believe this would be helpful. Now, we don't have a record of a reply to that email. Did you send one, do you think?
I'm not sure that I did.
If we go back to your statement, please, page 44, paragraph 126. If you go about halfway down that paragraph, you can see there are some words which say, I was satisfied. Do you see that? 5 lines up from the bottom of paragraph 26. I was satisfied, you say, by the responses provided by BBA that this was not indicative of any wider issue with their certification process. Had I had any further concerns about BBA's certification process, the only recourse available to me as a department official would have been to report BBA, a body wholly independent of the department, to the United Kingdom Accreditation Service, UCAS. Now, looking at Mr. Alban's response, as I've just shown you, he told you what corporate steps had been taken to improve BBA systems, but he didn't actually explain to you how the human error had come about, did he?
No.
Given the fundamental nature of the error and its serious safety implications that you yourself identified, did you not want to understand exactly how that error had been made?
I didn't think of that at the time, no.
Was the key point not to understand not what a BBA staff member had made an obvious mistake and simply not noticed, or whether the BBA wasn't training its staff properly, or whatever it is, but to learn why they'd made that mistake and whether it might have arisen from the way in which ADB was worded or perhaps structured?
That didn't occur to me at the time.
Right. On what basis were you satisfied that the misleading claim as to the combustibility of a widely used insulation product which had stood for many years wasn't indicative of a wider issue within the BBA certification process?
I think because they'd assured me that they'd carried out a review.
Right. Did you not think at the time it might have been wise to look further into this matter rather than accepting the assurances given to you by Mr. Alban?
I didn't at the time. I think in hindsight, or in retrospect, perhaps hindsight's probably not the right word, I think I should have brought it to the attention of UCAS.
Did you understand Mr. Alban when explaining the corporate actions that he said had been undertaken at the BBA to address the human error, actions that had already been undertaken before you contacted him on the 11th of July, or only as a result of your having done so?
I can't remember what I was thinking at the time. I'd be guessing.
Right. Because, of course, if it was before you contacted him, then the question would have arisen in your mind, one can assume, well, what was it that had triggered the review and the new improved steps? Did you have those thoughts at the time?
No, that wasn't something that I don't remember thinking that.
Right. Why didn't you press Mr. Alban for an answer to the question whether the BBA had actually notified Kingspan of the problem?
I'm not sure. I think I should have done.
He tells you in the email that there would have been dialogue and he would expect the matter had been pointed out, but that's not actually an answer to your very direct question. Will you be notifying the manufacturer? Is it?
I agree.
No. So why didn't you go back to him and say, well, thank you very much, but have you? Have you actually put this in front of Kingspan and asked them for a clear explanation?
I don't know why I didn't do that. I wish I did.
And in his email, and let's go back to it, I think we need to do that at BBA, this is the last document tonight, BBA 50178, page 1 there. This is the paragraph I read to you, which starts, there would have been dialogue with the certificate holder, and I would expect that this would have been pointed out. And then the certificate holder would not claim that the materials of limited combustibility, etc., etc. Now, Mr. Albon's assertion there that the certificate holder, Kingspan, did not make a claim of limited combustibility for K15 is true so far as it is intended to connote an express statement. But Kingspan certainly was impliedly claiming it, or letting it be claimed by BBA, wasn't it? Because of the statement that it was suitable for use over 18 metres by virtue of 12.7.
Yeah, I agree with your point.
Did you think to pick Mr. Albon up on that?
No.
Why is that?
I'm not sure why I didn't take this further.
Right. Mr. Chairman, it's gone 4:30. I have got about 5 minutes worth of more questions on this. I know it's been a long day and we're all tired, but it may be more convenient just to finish this off now rather than come back to it in the morning.
I can see that. You mean 5 minutes, do you?
I do mean 5 minutes this time.
Right, well, Mr. Martin, you've heard what Mr. Millett has to say. He reckons he's got 5 minutes more questioning. Can you hang on for another 5 minutes?
I'm here to help the inquiry as best I can, sir.
Well, I know you are. Thank you very much indeed. All right, well, we'll give Mr. Millett another 5 minutes.
I'm very grateful. Thank you. Now, Steve Evans had told you in his email of the 11th of July, and if we need to, we can go back to it, that the confusion has arisen from Kingspan's statement that their product is acceptable for use in a building over 18 metres. My question, did you read any of Kingspan's marketing literature for K15 when you were told by that claim by Mr. Evans?
I'm not sure now. I've read it since, so I can't say when I read it.
What was your reaction to Mr. Albon's comment in his email that we've still got on the screen, that he thought that the chances of anyone inferring limited combustibility to be extremely unlikely from the certificate wording? It's nonsense, isn't it?
I think I remember a general feeling of frustration with this, but I can't remember specifics.
Well, it's nonsense, isn't it? I mean, the chances of anyone inferring limited combustibility to be extremely unlikely is only correct on the basis that they didn't need to infer it because it was essentially stated. No?
I agree. Yeah.
I mean, at best, you must have realised that it was wishful thinking. And I ask you that. What else would someone have inferred from the words, the product therefore may be used in accordance with the provisions of approved document B 12.7? Do you agree?
Yeah, I mean, the point he's making in the email is that the only classification that's listed in the certificate is Class O. I think it's an inherent problem with the way BBA do their certificates, and they still do them like this now, where they talk about compliance with the regulations, whereas most other certification bodies tend to just confirm the different classifications that particular products got, and so it's a way of collating the information and confirming that it's been carried out correctly, whereas BBA tend to provide a commentary.
Right. I mean, you picked up the Class 0 point, correctly gave only a Class 0 rating. In what way or in what circumstances is a classification to Class 0 relevant to the question of whether it's of limited combustibility?
I think that's the point he's making, is that given that the only classification in the certificate is Class 0, it's clearly not a material of limited combustibility, otherwise that classification would have been in there. That's the point he's making. I don't necessarily accept that's...
Right. Are you aware now that the BBA certificates for K15 asserted that the product had achieved Class 0 on the basis of absolutely no test or other data, and possibly only on the basis of an extrapolation from other Kingspan products?
I've since heard that in evidence. It's not something I would have known at the time.
Right. Given what Mr. Evans told you on the 11th of July in his email about NHBC's reliance on the terms of the BBA certificates, did you consider suggesting to John Alban that the nature of the previous error and the correction which had apparently occurred should somehow be announced by the BBA, for example, on their website or in some other public way?
I can't remember if we thought about that at the time. As I say, the approach we'd taken to the whole problem was, having done this, was to see what NHBC found.
Very well. Mr. Chairman, is that a convenient moment?
Yes, Mr. Millett, if that's convenient, I think it's a good time to stop. Well, Mr. Martin, I'm sorry we've gone on a little longer than usual, but not as long as Mr. Millett led us to think we might. So we'll stop there. We'll resume, please, tomorrow morning at 10 o'clock. And as before, I have to ask you not to discuss your evidence or anything relating to it with anyone else when you're out of the room. All right?
Yes, sir.
Thank you very much. Would you go to the usher then, please? We'll see you tomorrow. Thank you very much, Mr. Millett.
Thank you.
Nothing else today. 10 o'clock tomorrow then, please.
Thank you, Mr. Chairman. Yes, thank you.